Welcome to the Secrets of Personal Injury Law with Colin Bober.
Welcome to the Secrets of Personal Injury Law with Colin Bober. Colin is a personal injury attorney who has represented over 4,000 clients with a gross settlement recovery of over $50 million. I'm your host, Abigail Vaca, and today's episode is the power of mediation in personal injury cases, a path to fair resolution. Colin, let's go ahead and jump right in. What role does a mediator play in personal injury disputes, and how do they facilitate communication between both parties?
Usually what happens, mediation is always court-ordered if the case is in litigation, so we have to go regardless of whether we want to. Nowadays, after COVID, 9 times out of 10, the mediation is done virtually, which is really nice, via Zoom. So they put us in different rooms and we present information to the the mediator that we've already given to the adjuster to determine, what we think the value is based on the information we presented. And the mediator serves as go-between between both rooms and says, the plaintiff is demanding this, the defendant says, well, we only want to offer this. And we go back and forth, and they serve as intermediary to justify the points that we're making, bring the points that they're making to devalue the claim for one reason or another. And hopefully within 4 hours, we come to an agreement as to a settlement.
So when is mediation typically recommended in personal injury cases? And what factors influence whether a case should be settled through mediation versus proceeding to court?
Well, a lot of times we try to do pre-suit mediation, which means, we already know which steps that the case are going to go through based on the requirements. And so if we know that mediation is going to be required, maybe we get a mediator involved early and say, we're not having much success with this adjuster. Maybe we'll try and bring in a mediator to kind of bridge the gap and be a neutral party to give them information that maybe we're not articulating the best way. And so if there's an opportunity to get a mediation done early and decrease the expenses of actually filing suit and not having to spend money on the depositions and discovery, then it's cost effective for us and the client directly. Like I said, if there's an opportunity to get it done without filing suit, that's an option. If the adjuster is not being agreeable and we want to go through discovery and collect all the information to bolster our position at mediation, depending on what the defendant may have said in a deposition or documents that were turned over in written discovery, maybe we want to collect that information first before we go to mediation so we have more leverage. And then when it comes to making a decision as to whether to settle at mediation, you kind of have to gauge those two things as to where are you in terms of a dollar figure? Is the client in a ballpark of something that they're willing to accept? And if they are, then, obviously that's their prerogative to accept it and you have to do what the client recommends. If not, then we just push forward with trial, but you also have to weigh where the client is at and how much it's going to cost to get them where they want to be. Because if you have an offer on the table and you're not very far apart, but then you add in a bunch of trial expenses, you might get a little bit more money at trial, but you may actually break even given the additional expenses. So you kind of have to weigh where you are, what the client's priorities are, and see if settling at that particular time makes sense or not.
Got it. So you just touched on this a bit, but are there other key benefits of mediation for personal injury victims compared to going through that lengthy trial process?
Well, a lot of mediators, especially the ones we work, have either our attorneys, have been adjusters. They really bring that background information to the mediation and you use it as an opportunity to bring information to light to both parties and say, you may consider this. I've seen this play out at trial. You might want to be careful about, demanding too much, because if you're too far apart, then you're just going to sit there staring at each other until one of you makes a move to get it done. So the background of the mediator really makes a difference to offer that expertise to both sides to get both sides to come closer to an agreement to see if you can get it settled.
That makes sense. So how do you, as an attorney, prepare your client for mediation? And what are the steps that you take to ensure they get the best possible outcome during the session?
We want to give the mediator a copy of our demand that clearly articulates our damage model so that they understand where we're coming from and they can see it. We do that because the other side also has a copy of our demand, so everybody's on the same page. Because the worst thing you can do is go into a mediation and shoot for $1 million, but there's no justification for it, right? So we want to make sure that we give the correct information to the mediator to give them the background as to why we are where we are. And then we prepare our clients and let them know, settlement in itself with an insurance company is a business decision. So obviously, if an insurance company has the opportunity to resolve a claim for a lesser amount, they're going to take that opportunity. That's their job. And so you have to set the client's expectation. Their offers, the first one's not going to be great. You're not going to want to accept it, nor should you. So, and a lot of people get offended based on what that first offer is, because you're like, you got to be kidding me. Like, that's where we're going to start. And that's the point. Is it's supposed to be a conversation. It's supposed to be collaborative with a neutral individual to help facilitate a final resolution. And so setting the expectations at the beginning is really important, because if the whole thing blows up because expectations weren't set, then you missed a really good opportunity to get the case settled potentially for less expenses to the client.
That makes sense. So to elaborate on that, how does the mediator ensure that both sides are being fair during the process? And what can clients do to feel confident that their interests are being represented?
The whole process is designed to protect the client's interests, which is why they need to be there to participate. Some lawyers will mediate and the client says, I don't want to be a part of that. Just get it settled for me and give me as much as you can, which is their prerogative to do. I mean, a lot of people don't want to be involved in this process in the first place, but the best way to protect their interests is to give them the opportunity to be there. So especially when we have clients with severe injuries, we can submit in writing what we believe their experience was, lasting symptoms, how it affected their life, but it's also beneficial to have the mediator hear it directly from them. And a lot of clients feel more at peace going into mediation, whether it's settled or not, because they got the opportunity to have their voice heard themselves, and a lot of times, like I said, we provide documentation in advance that they've seen themselves, so they know what's been submitted and they can participate in whatever the other side is saying, whether it's accurate or not, and push back themselves and say, no, that's not true at all. This is what happened. And the mediator can also go back to the other side and say, this plaintiff sounds very credible. You might want to consider that in your evaluation, because if it doesn't settle today and goes to trial, this plaintiff is going to look really good on the stand. And since it is a business decision for the insurance company, they factor that in terms of how would the plaintiff appear in front of a jury. So it's very important for them to participate so that they have confidence that when it's said and done, either it settles and they got to participate, or it didn't settle and at least they knew, they were present to see how the other side is acting when it comes to the evaluation of their case.
That makes sense. Everyone is the expert in telling their own story.
Correct.
So how does mediation impact the timeline of a personal injury case? And can it help clients get compensated faster compared to, let's say, traditional litigation?
Yeah, so like I said, if we have the opportunity and it makes sense to propose early mediation, then we'll take it. And it does give the opportunity to settle earlier. I mean, like I said, too, mediation is always required before a trial by court order. Either way we're going, it's just a question of when we're going and when it makes sense to do so. If we want to go through discovery and collect all the information because we think it's going to strengthen our bargaining position based on the information we collect, we'll do that first. If we don't feel like we need to do that and mediation is an option and the other side's willing to agree, then we may ask and see if they're willing to. And if they do and we can get it settled, then it will have a direct impact on them because it will settle a lot faster. But every scenario is different, and you have to weigh the interest of the client and what the other side is saying in negotiations as to whether or not that makes sense.
That's interesting. So what happens if a mediation doesn't result in a settlement?
We go to mediation and it doesn't result in a settlement. It depends on at what point did we propose mediation? Did we propose it before we filed the lawsuit, or did we propose it after? Because if we did early mediation before we filed the suit, then the next thing we do, of course, is to file the lawsuit and start the process of discovery, and then we go again. If we did it after we filed suit, then the only thing you can do is get ready for trial and hope that the other side is willing to come to the table right before and make a better settlement offer. So it really just depends on at what point did you initiate the mediation process.
I see. Are there other options to continue negotiations, or is it, like you said, the case automatically goes to trial?
Well, like I said, the insurance company can propose a settlement at any time. mediation is the best opportunity to get it done because both sides are at the table. We're all talking. We're trying to get it resolved. And sometimes insurance companies like to wait until the very eve of trial before they finally make an offer that the client is willing to accept. And that's what I meant earlier in one of the podcasts is you're trying to present enough information to the insurance company for them to realize what a jury may award, because if they want to roll the dice and put it in front of a jury and the jury offers a lot more money, then they're going to wish they had settled earlier. You're trying to present that information as to what you believe is the plaintiff that would happen if it went that far, so that you can prevent it from going that far by getting them to offer the money up front.
That makes sense. Do you have any examples?
We went to mediation recently where the insurance company said, we didn't do it. And I'm like, well, according to the police report and testimony from my client, you did. And so the insurance company denied the demand. We proposed early mediation and we settled it in the six figures because we were able to have him participate and explain exactly how everything happened. The insurance company didn't really want to spend the cost of defense to go through the whole process. We just had to give the client the opportunity to say what it was he needed to say about how it happened, what he experienced. And the insurance company said, you know what, this is not going to look good. And so they offered a six-figure settlement and he was a happy camper. So, there's a lot of opportunity to get it settled early, as long as the information provided to the insurance company makes them believe that it's also in their best interest to do so. Which is why, basically conversation from a previous podcast relating to how important it is to get information quickly and from whom. That's when that information is important, because that's where we show, hey, we have a witness that says your driver was drunk, or we have a witness that says your driver did run the red light, or we have a family member willing to testify that, you broke this client's neck and he needs therapy for the next 2 years. That kind of stuff. That's when we collect it, and usually in mediation is when that information really comes to light for them to make a decision as to what it is for the insurance company in their best interest to decide to settle or not.
Wow, that's a great outcome, though.
It was.
Well, this was really enlightening. Thank you so much, Colin.
Sure.
And thank you for tuning in to The Secrets of Personal Injury Law with Colin Bober. To connect with Colin and his team, visit boberlawfirm.com, and please be sure to like, subscribe, and leave a review on our channel.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.